here. Okay, so as part of our annual training component, we try to focus on some aspect of what's contained within the guide. And maybe some years it's one thing, maybe it's a couple things. But this year, the executive committee decided to take a look at changing a proposal for decision and kind of the law and practical aspects of how that is accomplished. So I'm going to jump right in. So some of you have seen this chart before. I really only show it to you to kind of help you identify where in the process a PFD is actually relevant or where it occurs. So I know you cannot read this, but what we're talking about is really right over here, where the SOA hearing is held, a proposal for a decision is issued. And why is that important to note? Well, when a complaint is filed, it is possible that any complaint can ultimately result in a case before SOA, or the State Office of Administrative Hearings. I think most of you know that's essentially state agency court. So if a SOA hearing occurs, an administrative law judge or an ALJ, there's lots of acronyms when we talk about this world, they'll review all the testimony and the evidence presented during the hearing, and then they're going to issue something called a proposal for decision, or a PFD. We just looked at one in the contested case today. So what does a PFD contain? Well, you've seen them. They can be quite long. They can contain a lot of information, but for our purposes, the most important parts are the findings of fact, the conclusions of law, and any recommended sanctions. The findings of fact are sort of as the name suggests. They're things that the ALJ has found to be true. So an example, John Smith is a licensed real estate sales agent. Pretty standard example of a finding of fact. There's also conclusions of law, which are based on the facts, what legal conclusions has the ALJ made? These are questions of law. So, an example you'll sometimes see is Mr. Smith's offenses are directly related to the occupation of a real estate sales agent. If you're paying really close attention in today's PFD, you'll see that something like that was actually a finding of fact listed in the PFD. We'll get to why that may be important in a little bit. But typically you see that in conclusions of law. And then finally, you've got recommended sanctions. You'll typically see these also as a conclusion of law, but they are somewhat separate. And an example, the commission should impose a $5,000 administrative penalty. Okay, so when we're talking about findings of fact, we actually break it down a little bit more. And I'll tell you why this is important in a second. So with findings of fact, there's basic facts. Those are the who, what, when, where, and why. Then there's ultimate facts. And those are standards that the agency has to decide in order to make a final decision. So those usually involve, those are different from the basic facts because they usually involve, gosh, my computer just died. That part out something? I don't think it's It's connected to Sorry, everyone. Is it like you put? You want to connect it over here? Yeah.
If you here, and then just slide it down, and Abby and I can change it.
Okay. Always something.
Your way.
I know.
Yeah, we lost one. Fried one.
I did have a paper. Okay, so while this is starting back up, I'm going to just keep going.
You're doing a great job. That was throwing me for a look. I mean, do you want me to sit there and click while you stand up front?
Oh, yeah, that'd be great.
No, I can.
I think I have to read it.
Yeah, yeah.
There's gonna be a pop quiz on the last slide. She just went over.
Sure.
Oh, are you here for the broken power strip?
Broken power strip.
Yeah, we're good for it.
Circus.
It's okay, we're running at a deficit, we don't need no service.
Yeah.
Okay.
On behalf of Renata.
Okay. Okay. Just appeared. Incredible. Wow. All right, so we've left off at ultimate facts. So these again are standards that the agency has to find in order to sort of move on to the final decision. So they usually involve conclusions of law or a mixed question. So sometimes they look a little bit like a fact, sometimes it's a little bit like a law. And they don't always concern the specific parties, which is why we, as an agency, care about them, because they can have a broader impact. So they help decide questions of law and policy. So again, here's an example that you might actually see as a finding of fact or conclusion of law, depending on the ALJ. But Mr. Smith has sufficiently established his honesty, trustworthiness, and integrity to be licensed at this time. Okay, next slide. So for us, for TREC, it's really important to remember that a PFD is a recommendation. It's a recommendation by the ALJ to the commission. And that's not true of every agency. Depending on what the statutory authority is, sometimes the ALJ can actually be the ones to make the final decision. Sometimes the ALJ, basically the agency has complete sort of authority to make a wide variety of changes. What we can do is limited. So even though it's a recommendation, there are limitations. So generally speaking, an agency is not permitted to change a finding of fact, a basic fact, I should say. And why is this? If you think about it, it's the ALJ who sat there, has listened to the testimony, listened to the evidence. They've weighed everything. They've listened to the credibility of, the respondent or the complainant. And they can't, the agency can't retry the case. The courts have been really clear about this. That's one of the reasons you'll note sometimes you hear, you've got to stick to the record. For the agency to stick to the record, because again, it's the ALJ who's sort of gone through everything, issued this PFD, determined what's relevant. So that's a basic fact. Agencies have a little bit more flexibility when we're talking about an ultimate fact or a conclusion of law. Still, if you're going to make change there, and there's still limitations on what you can do, that'll be the next slide. But there has to be a reasonable connection, what you're deciding versus what underlying facts are there. That has to be a reasonable sort of conclusion. And then last but not least, agencies have the most flexibility to change sanctions. And that also kind of makes sense too, because courts generally say, agencies, you're the experts. If there's been a violation established, it should be up to you to sort of determine what that penalty should be. So pretty broad discretion when it comes to the appropriate sanction. Okay, so that's kind of the areas that you can change in a PFD. What does the APA say? Well, the Texas Administrative Procedures Act, it governs all state agencies unless there's a specific exception, says that a state agency can change a finding of fact, a conclusion of law, or an order, only if the agency determines one of these three things. So number one is that the ALJ did not properly apply or interpret applicable law, rules, policies, or prior administrative decision. This is typically the one that we use the most. If we're changing a PFD, we're going to say, ALJ didn't quite get it right. This is not what the law says. You made a mistake. Number two is that a prior administrative decision on which the ALJ relied is incorrect or should be changed. We don't often use that one. Number three, we've used probably a handful of times, 2 or 3. And that's a technical error in a finding of fact should be changed. And really, I think that's like a typo. There's truly a typo in the PFD. So in order to change a finding of fact or conclusion of law, and keep in mind, we generally can't change basic facts, so we're really talking about ultimate facts when we talk about finding of fact, or a conclusion of law, the agency must determine one of those three things have happened, and then we have to state the reason and the legal basis for that change in writing. I think it's on the next slide. Well, I'll talk about it now. It may already be on the slide. But that's one of the reasons that we ask up front, if you have questions about a contested case, especially if you're thinking about changing a PFD, it's really important for us to know, if we can, ahead of time, because there's a lot of work that GCs do up front to try to anticipate what changes you may want to make, and it's kind of a time-consuming process. So any heads up that we can get is always much appreciated. Okay, so changing a PFD, here's an example. And this is one some of you may recognize. I tried to take out most of the sort of details, but this is, this is something, well, you noticed, yeah. So a license holder pled guilty to numerous felony offenses. This is a real life example and a situation where we, the agency, changed the PFD. So the license holder, in addition to having those guilty pleas, failed to notify the commission and failed to provide requested information to the commission. Staff sought to revoke the license and assess an administrative penalty. The ALJ, however, after hearing all of the evidence and testimony, recommended only an administrative penalty. The commission ultimately changed the PFD and revoked the license. And how and why did the commission do this? Well, the commission didn't change any of the findings of basic fact. Basically, the commission took the position that, oh yes, all of these things are true. We're not disputing that all of these things are true. But because all of these things are true, we have a different recommendation for a sanction. So that's an example of where you can see that you have a lot of flexibility in changing sanctions. Ultimately, that case was appealed and the district court upheld the decision. So that's a situation, again, sanction was changed. Sometimes when you change a sanction, you have to sort of back up a little bit and change some of the conclusions of law. Sometimes when you change conclusions of law, you have to back up a little bit and change some of the ultimate findings of fact. We did all those things in that case, and ultimately we're successful. But we didn't touch the basic facts that the ALJ found. So what does this process actually look like? So I kind of gave you a sneak peek of this, but before the meeting, GCs will review the case and try to anticipate whether you all will have any changes that you want to make. We try to look into the future a little bit. We actually sometimes and frequently do draft a few different versions of a final order just to be prepared for any changes you may want to make. But again, it's helpful to know upfront if we know for sure. So during the executive session, GCs will help draft a motion to the extent you need that help to help change that PFD if that's what you're looking to do. And then, of course, a motion has to be made during the open portion of the meeting, and then ultimately the commission votes. And the chair will sign the final order. Okay, so that's if you can, under the law, if you can change the PFD. This is, should you? Are there other reasons you might not want to change a PFD, even if legally you could change it? And the answer is yes. The question is the juice worth the squeeze? So, for example, let's say the administrative penalty ultimately recommended by the ALJ is different, but still reasonable. We saw that today. There was a little bit of a discrepancy. If it's still reasonable, then that makes it more difficult to show that the ALJ erred. And anytime you're changing a PFD, it always comes with some risk. And by risk, I mean there's a chance that if a reviewing court takes a look at that, we have to be able to show, again, one of those three things. And so there's risk if it's still a reasonable determination by the ALJ that the court won't actually find that, hey, there was a misapplication of the law or something like that. So there's always that risk. So the balancing act kind of comes into play. does the risk of unfavorable precedent, and I'll explain that in a second, outweigh the change to the administrative penalty in this case? So anytime you got a case that goes to court, district court, there's always a chance, you know, it can go all the way on up as well. And there's always a chance that that can establish precedent that's not favorable to us. So these are all the things you kind of think about. And these are not things you have to decide or make a determination on your own. GCs can be there to kind of help make those recommendations when appropriate. But ultimately, that's kind of the test. Importantly, even if a PFD is not changed, and we've said this many times, and Vanessa has said this many times, you feel strongly about some aspect. There is still power in conveying that message in an open meeting, even if you don't change the PFD ultimately. I think that's all. Is that my last slide? Okay. Any questions?
On that last bullet, why do you think there's still power in saying it in an open meeting?
Well, you know, meetings are, as the name suggests, they're open. They're watched by the public. They're, you know, recorded and watched later by the public. And so when a commissioner says something, people sit up and they listen. And so, you know, that has power. That can be a negative sometimes and a positive. But there's power in things that you say, particularly in a meeting when you're hearing that particular case.
So that, I mean, today's comment about temporary suspension, that's exactly what I was doing. I know
Yeah.
the statute does not allow it.
Yes, that's a great example.
But, I mean, we got to voice it out that, hey,
Absolutely.
this is something that really needs to get looked at by some.
Yeah.
Legislatively, unfortunately.
No, that's exactly right. That's a great example. You know, if you don't agree with, you know, the decision of the commission, for instance, I mean, you can still make that, you know, that voice that concern or what your opinion is too, and there is power in that as well. So, you never want to feel that even if you don't change the PFD, that, you know, you kind of lost the opportunity to make a point, because you can still make a point.
I'm curious about one thing.
Yeah.
Just more than curiosity.
Yeah.
So in that case, that was St. John, or was that the one from Dallas?
This was the example. That was a couple years ago, the Walton case.
Oh, the one. Okay. So that goes to district court.
Mhm.
Is that district court just like any other district court trial, like in front of a jury?
Well, no, it's usually just in front of the judge, and the standard of proof is a little bit different. What they have to find.
Just curious.
Yeah.
Is the standard of proof more difficult or not?
I believe it's substantial evidence. So that means essentially, and I'm going to butcher it if I try to tell you exactly what that standard is. But you know, so if you start out in district court, most of the time it's called trial de novo, which means everything is fresh, everything is new. There's no one is giving any sort of credit to what the agency decision was previously, or you know, some type of decision. With substantial evidence, there is, I believe it's like the standard is you have to show arbitrary capriciousness or something is the language. So it's a higher standard for sure.
I mean, one of the questions that I've always had with respect to some of the cases that go to solo. Do all cases end up in solo? Because,
No.
I mean, it seems like the ones that should not, I mean, it's clear that they're going to lose it. So why? Is it because the respondent said, hey, absolutely not, I'm going to fight this till the end?
Yes.
And it's like, you're going to lose. So you're wasting all these resources. So
It almost seems like the SOA cases are like, you know, the ones that would make it on TV. Right? If we were doing this like in a Judge Judy setting, the SOA cases are the ones that would make it on TV because they're so ridiculous.
Yeah.
Like, I forgot to pack the bullets when I was going to kill someone.
my goodness, it's like, you know, we had one where there's like multiple cases, multiple felonies, and then there was sexual abuse of a child. And it's like really, you're gonna fight this all the way to solo? It's just ridiculous. And so you don't have that ability to. I mean, it's on them. Right?
They have the right. They have the right, and if they choose to exercise, you know, to the maximum their rights in this area, they can do that, and we'll participate along the way. But that's a right that they have. A lot of folks don't pursue that. We'll go an agreed order route, for instance. But if they want to fight it, they can, and we'll go to sell it.
And those are the ones where I guess the bigger they not to lose.
Good thing.
Except for
Yeah.
money.
Exactly. Imagine somebody's asleep. It's gonna be.
Well, except like you said, mine.
Well, it's often, I mean, if you're represented, it's possible.
Well, it is, but
Not
some of these folks, I mean, well, it's not.
He's right.
I mean, it's either the people don't think they did anything wrong.
Yeah.
It's in their mindset, like, it's just how they're psychologically built. I mean, we've all had people, regardless of what they've done, you may you didn't learn right or wrong when you grew up as a kid, or they had nothing left to lose.
Yeah.
And a lot of times you see where they've just gotten lucky because they just think people asleep, or is that a judge believed them some way, one or another, or they're just really good liars. Things like
We should that.
Yeah. Okay, that's nothing to lose.
yeah, I mean it's kind of like
It's in their mind.
The vast majority of the cases are settled through agreed order.
This is a
You're
small
gonna be airing the
percentage.
laundry.
But the important thing is you always kind of have to think, well, if a complaint is filed, it could end up at so what? It could. Doesn't mean that it will, but it could.
Never forget the $3,000 penalty one.
Oh, yeah.
Went all the way, appealed all the way up in the courts. I mean, because
Yes.
if people think they've got, they did not think they did anything wrong in that case, and they took it to the mat. And I'm sure when they opened that case, no one thought that one was going to go all the way.
That's good.
But enforcement prepares every time as though it's going to go all the way. And, ultimately, the commission prevailed on that case. So.
And the unfortunate thing is that even though they did do wrong, their license has to go back to active until it gets completed.
They go through the process.
well,
Except the
so if they appeal it to district court,
That's a
No.
different, yeah.
they'll
Right.
say that unless, and I've never seen this on TREC's side, you can file for injunctive relief, but like say we find someone $50,000, they'll have to put that $50,000 bond into the court registry in order for them to even maybe possibly get an injunctive order from the judge saying, no, you can go back to active until this is resolved. I've never seen that happen, but it is a possibility.
so generally all cases will end for the respondent on the denial of motion for hearing.
Yeah, if there is a motion for a hearing. A lot of times there isn't.
Right.
At the very last.
But that's the
But
very
once
last.
it's
Not for district court.
basically, unless it's overturned, or there's an injunction, like Mike was saying. But really what we're trying to get is to a final order, and that is determined by the APA, what is considered final in those cases.
I think where you're remembering the appeal is for a criminal history case. Criminal history, if someone was found guilty, but then they appealed it, and we cannot use that conviction until that appeal is complete. We talked about that a couple months ago, so I think that's where.
Yeah, that was a federal case that took forever.
That concludes.
That's all I have for you.
Are there any other questions?
So for the newer members, new listing in particular, I mean, it's coming in with the PFDs and all that whole process must be pretty mysterious. Did this help any in terms of just
Well, I'm under construction.
you're under construction? Because, the thing is, when we come into the, into the executive session, of course, we will have had that information, sent to you. So you've got the information ahead of time. The idea then is you can talk to Andy before the meetings, et cetera, ask questions around, that you might have. And then when we get into meetings, after we hear, the case or any, maybe the attorney shows up or whatever, then we have another, kind of bite at the apple here. And, first ask questions. You just can't sit around and talk about, say, okay, here's what we're going to do.
Yeah.
It has to be independent, deliberation, developments.
I mean, why do different state agencies have a different standards for those PFDs, whether we can change them or not?
The language in their statute is different, is the simple answer. Why the language in the statute is different. I think most of, at least the ones I'm aware of, it's the medical agencies that have maybe, well, that's not true. There's TMB, Texas Medical Board, TCEQ, PUC, I think is another one. So all of those agencies, and again, I don't know that I know why they have
Different risks, different.
That's probably it.
But think about what those agencies.
But they basically have more flexibility to make changes to a PFD than what most agencies have. They're kind of the unique exception.
The in-house expertise as well at those agencies, in making some, I think if you look at something like TCEQ, having their staff dig in, or their commissioners dig into something, there's a little bit of a difference in expertise level. Arguably. Commission on Environmental.
So it's like water issues, permitting issues.
Or the utility commission, things like that, yeah.
Okay. Well, unless there's any other questions, the only thing left is request for potential future workshop agenda items, and then that's it.
Anyone have any workshop items they'd like to pitch out?
Hawaii.
Yeah.
What?
Hawaii.
Hawaii. Yeah. Oh, yeah. Yeah. Well,
I say instead of Houston,
that's,
I thought you replay were not a state.
Yeah. I don't know how that plays with our fee increase request, Yeah, when they come and say, for this fee increase, we're going to cover the trip to Hawaii.
Yes. Chair Woodruff, that's actually pretty relevant in that Arello is meeting 2 times in 2026. The first one is in Kentucky, and the second that's in the spring, and the second one in the fall is in Maui.
Oh, that's a good one to go to.
Right.
Oh.
We have elected not to attend
Oh.
at all. If you want to go back and Google the Texas Alcohol and Beverage Commission kind of scandal many years ago, they went to a regulatory conference in Maui, and I'm not the executive director later resigned. The board turned over the criticism they received, not from going as much as the cavalier way in which they went. What was an issue, but it's enough to where I don't know that Texas agencies can travel to Maui thanks to TABC. And so we just said we're not going to.
There's a touch of
And so if you'd like to go, you're welcome to. It will be on your agenda.
Got it.
Make it be known.
Yeah. Okay. Good deal. Understood.
Got the
Little bourbon
Yeah. All right. So if there's nothing else, thank you all for your service, and we'll see you in a second.
Okay.
Happy holiday. Yeah, I was thinking that too.